Hello, everyone, and welcome to Immigration Talk Show. I'm really happy that you have joined us. We are streaming live right now on YouTube, and you can also check us out on LinkedIn, Facebook, X, and Instagram. And feel free to join us by commenting wherever you're watching us. Also, you can join us on call, and the number is 425 and the access code is 988 888. And before we head on with today's discussion, and also have our guest for today's lined up webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, today's discussion is going to be a very important one as we know that just yesterday the filings closed. The last date was yesterday at 12 noon. And today's discussion is going to be on the H1B lottery, which is coming up ahead. So, what to expect, and the RFE risk, and the SOC code issues, and employer guidelines. And to help us, know more about this topic of discussion, we have none other than our guest for today, Attorney Justin Rivera from Wasden Immigration Litigation. Justin, it's always really nice to have you. Thank you so much for joining us today.
Yeah, absolutely. Thanks for having me. Looking forward to the opportunity to discuss the lottery in a little bit of detail as we close registration and head into that anxious waiting period in between when selections occur and when people figure out whether or not their employers are going to file for them. Which my understanding is we should probably know next week. I think, right? Usually April 1st. Yeah. So I think we should probably start knowing by the end of this week or going into the beginning of next week. So we'll wait and see, but fingers crossed for everybody that has a registration pending.
Absolutely, Justin. And here's wishing each one of you all the best. But what are your thoughts? And how busy were you, by the way, till yesterday, Justin?
So we luckily finished up on Friday. We made the determination internally that we would not be accepting additional candidates after end of day Friday. So if you weren't into us by Friday, we weren't going to work on your case. So what we did was we finished everybody up Friday afternoon, going into the evening. We worked with our employers, the sponsors, to get everything submitted. Everything went off without a hitch, I have to say. I am a very critical person of USCIS, deservedly so, because I don't think that the agency operates with any level of real efficiency. But I will say that the registration process was fairly smooth. I ran into very few hiccups and errors. There was, maybe 2 times where the system couldn't really properly be accessed, and it took a lot of time to log in. But other than that, pretty smooth sailing. So yeah, we finished up. We had a decent number of registrations for it being our first year operating as a filer, in addition to the litigation services that we offer. So we had a good number of people. Looking forward to seeing what comes in. As we were kind of talking about before the call, I'm interested to see the selection rate because my assumption is that the combination of the incoming administration along with the increased fee might lead to an increase in selection rate because I think less people are going to have applied this year. However, that's a hypothesis that will need, data to confirm it. So we'll see what actually happens. But that's my thought and my hope.
Sneak peek into what was happening. Thank you so much, Justin, for telling us what was happening, at Boston Immigration Litigation. And from what we hear in the news, we also think that could be that registrations would run short and there could be another, um, you know,
Another lottery. Yeah, a lot. There's a lot of chatter about a second lottery already, which is amazing because we haven't even done the first one. um,
I know.
I think maybe you see a second lottery. It's definitely a possibility. But really, that data, in order to really figure out when that would occur, is we have to see how many people file from the first selection group, and
And
send,
we
and
will
then
have that by the end of this week or by next
no,
week.
no. I think we'll probably start getting that picture in May, closer to June.
Oh,
I think if I remember right, don't quote me on it, but I think that's usually around when we get the update from USCIS as to whether or not they're going to run a second lottery.
mhm.
That can always change circumstantially. I mean, maybe they know ahead of time. They're like, wow, we're nowhere near the cap. and then they make that determination sooner. I would always love for them to do it as soon as possible because, like most people, I like to go on vacation in the summer. And I would prefer to comfortably go on vacation rather than have my assistant message me and say, hey, we have, 35 more cases to file because they ran a second lottery. But that being said, if it's beneficial for our clients, then I'm all for it. But we'll have to wait and see. I think that the immigration community, the immigration legal community is leaning more towards the second lottery than there not being a second lottery. And that's just when you're looking at the factors of, like I said earlier, the increased fees, the fact that I think there are just going to be some people who sit out this year in registration. We were talking about it before the call, but I actually do have a client who is just sitting this year out. They said, look, we have X amount of people on H1Bs. We don't need to bring in more Hs. We would like to, but the fact of the matter is we want to see how things look post first year of Trump 2.0 prior to making the decision to put our foot back in the filing game. That's all right. If that's the decision you want to make, that's the decision you're going to make. I think that that's very possible that other companies are going to follow that opportunity, that decision. But what that means is there is an opportunity for people who maybe don't have as high of an option to be selected. Maybe someone, for example, who's only in the bachelor's cap, but where now that the pool is smaller, you're increasing that probability of selection, especially when it's coupled with the possibility of a second lottery. So we'll see, but those are my honest predictions. I think we'll probably see a good selection rate, more so than what it usually is, and then more likely than not, we'll
Yes,
see.
actually, yes, that too. Because, with all the rules and becoming beneficiary centric, and no, I mean, one person is only qualified once, and so many things. I think registration, and there could be lesser mistakes, and I mean, I hope so. So let's see what's going to happen. And I think we should, get on to today's topic and
Absolutely. I'm just
question.
happy before we
Yeah.
get started. I'm just happy to never have to do the stuff that we did when I first started practicing, which was where we had to send everyone's petitions in at the same time. That was horrible. I would much rather do this type of a lottery because prepping 500 people's cases, knowing that only like 15% of them were going to be selected, was always a tough situation. So I do like the way that they do things now. Anyway, sorry for cutting in.
No, it's cool. It's cool. And I think we should come back to today's topic of discussion and also, discuss some of the questions that are prepared. So, my first would be to get to know, Justin, how important is selecting the correct SOC, or the Standard Occupational Classification Code? And what are the risks of choosing the wrong one?
So your SOC code is one of the ways USCIS can attack an H1B. And the reason for that is your SOC code is it's in your labor condition application. And what the SOC code says is, officer that's reviewing my case, I am this role. Let's say I am a software engineer. What I do is most akin to the SOC code that's been provided, and that would be maybe software developer. So what the officer is supposed to look at is this person who is a software whatever was in the software developer SOC code, are their job duties tracking properly with what a software developer does as per the SOC code? What do they look at when they make that determination? They look at what's called the ONET and the OOH. These are both basically databases that the government utilizes to review positions to ensure that the position aligns with the specialty occupation or that it's within the correct SOC code. So that's what they look at. And when they're looking at that, they make an assessment of whether or not the position properly correlated to the SOC code. What they can look at also, in addition to that SOC code, is whether or not it is applicable to the proper wage level. So let's give like a quick hypothetical, just so we're all on the same page before we move forward. Let's say that I have a guy who he's a computer systems analyst, but I don't like the computer systems analyst SOC code. So what I want to do is move him into a software developer SOC code so that we have a better chance of getting an approval because a specialty occupation looks better for one position versus the other. Let's say you do that hypothetically, and then you file the case and you say, hey, my guy's an IT analyst and I'm filing under software developer, but all of his job duties are for a computer systems analyst. It's very possible in that circumstance that USCIS can come back and issue an RFE saying that an improper SOC code was utilized, basically arguing that the LCA, the labor condition application, is deficient because the wrong SOC code was chosen. In that circumstance, you then have a very difficult request for evidence to overcome, where basically you have to convince an officer that already is assuming you picked the wrong SOC code that you did not pick the wrong SOC code. You have to do that through a litany of arguments that you need an attorney to do. Probably wouldn't recommend doing that on your own, but it's a hard, it puts you at a disadvantage, definitely. And that's kind of the problem. The SOC code is chosen when you file the LCA, which is basically the first step when you're actually filing an H1B. What people need to understand is when you're filing the labor condition application and you're choosing an SOC code, you need your job duties ironed out. It's not a say what the position is and then figure stuff out later. You should know what the person's going to do. That way you have a rational basis between what SOC code is chosen and what wage level is chosen as well. Because along with that SOC code, you're dealing with whether or not this person's a level 1, level 2, level 3, level 4 wage, which is all contingent on job duties. So in essence, the job duties are kind of king. They will dictate or should dictate the proper SOC code and wage level, both of which have the potential to be questioned by USCIS.
All right. Thank you so much, Justin, for taking that up. And folks out there, you can also join us on call. The number is 425-436-6335, and the access code is 988-888. And I see Ananya joining us. Hi, Ananya. Thank you so much for joining us on YouTube. Let's quickly take up Ananya's question, Justin. And she's asking, my employer filed an H1B registration for me, but I'm worried about the upcoming lottery. If I don't get selected, what's the smartest way to maintain my legal status, especially since my OPT is expiring this June?
So if you have OPT, I don't know if STEM OPT is available, or if, that's kind of contingent on what your degree is. If STEM OPT is an option, obviously I would apply for STEM OPT as soon as possible. Don't put all your eggs in the basket of my case is going to get selected in the lottery when you have a secondary option. Again, I don't know what degree level you're at, but if you are OPT is expiring and you don't have a STEM OPT option, or you've utilized all your STEM OPT, I think another potential option is moving up a degree level if you want to continue your academic studies. So let's say that you got a bachelor's degree, you want to move up and pursue a master's. If you move up a degree level to pursuing a master's, you can sometimes have the option of doing CPT. That's going to be specific based on the university, but that could be something to explore. Or if you don't even want to work at all, you can just continue to go to school with moving up a degree level. So I think those would be kind of the simplest ways for you to maintain status if your goal is to remain in the U.S. Other than that, there's obviously the change of statuses for dependents. If you're married to an H1B holder, there's an H4. L1, there's an L2. E3, E3D. Like all of those are optionable as a dependent visa, but obviously you have to be married to get those. So I think those are kind of some basic options. B2 is also always like a very low tiered suggestion option as well, but those are some options for you. But hopefully you're selected and you don't have to worry about it.
Thank you, Justin, for taking that up. And thank you, Ananya, for participating. I'm so sorry about my throat. Lokesh is also asking, and also Komal. Hi, Komal and Lokesh. Thank you so much for joining us on YouTube. Komal is saying hello, and how many applications can we expect this year? Well, that is hard to predict.
I can't help you there. I could probably help answer Lokesh's question, but Kamal, to give you like kind of a general idea, I think that you're going to likely see less applications than you saw last year. Would be my honest bet, and I think that's probably backed up by most people in my field. Is that the increased fees coupled with the new administration's kind of more anti-immigrant rhetoric is likely going to lead to a lower number of registrations this year. I mean, there are already, not myself, but there are already attorneys that are willing to go on record at this point and say there's going to be a second lottery just because there's not going to be enough applicants. And that's probably anecdotal, honestly. They're probably looking at their own filing numbers and saying, well, we filed let's say hypothetically 1,500 cases last year, and this year we only filed 900. So if we're seeing that decrease, it's possible across the board. My firm doesn't have that data because this is our first year doing registration. So we're starting fresh. But that being said, from a firm that I worked at previously before coming over to Wasden, I know that they had a good amount of registrations last year because I helped take part in it. I know that this year they were done a day earlier than they were before. So that fact probably makes me think that we're going to be, looking at less registrations. So yeah, we'll see the numbers, but I would assume lower.
That up. Thank you so much, Justin, for taking that up. And now we have, RK. Hi, thank you for joining us. Let's take up locations. I heard there's been a rise in RFEs related to specialty occupation lately. My job
Absolutely.
title is, data analyst. And how likely is that I'll get an RFE, and how should we prepare proactively to avoid a denial?
So that SOC code, if I remember right, which I just cheated. I don't have a photographic memory. I use the powers of Google. That's an operations research analyst. So an operations research analyst is an okay SOC code. It's not a terrible one. It's decent, and it would lend itself likely to a data analyst. So specialty occupation under the new regulations basically, requires a degree in a specific specialty or a degree that's rationally related to the duties that are being performed. When you're looking at specialty occupation, you kind of look at, as a basis, what is it that the ONET shows the position is doing in the OOH, and what does the ONET and OOH say about what the position typically requires. So just looking at this right now, the Operations Research Analyst SOC code is actually in Job Zone 5, which is extensive preparation needed. So if you look at the education requirement, most of these occupations require graduate school. For example, they may require a master's, and some require a PhD, an MD, or a JD. That's all fantastic language that you could use in an RFE response. Right off the bat, you take the weapons that the government tries to use against you, the OOH and ONET, and you push them back in their face and say, by your own standards, these jobs under this SOC code typically require a degree in this field. Another thing that I like to look at when I look at the educational requirements for the field, if you look at this SOC code, I mean, it's fantastic. There's no degree here that's below a bachelor's. 33% bachelor's, 43% master's, 14% doctoral degree. Everyone that does this position needs a degree. And as long as the degree requirements rationally relate, it's a specialty occupation. So I would say you're in a solid SOC code. As long as your job duties properly line up, I think you're in a great spot. I wouldn't be too worried about a specialty occupation RFE. Now, that being said, I will tell this to everyone that is watching today, and anyone who watches a recording of this in the future, because I'm just telling everyone, even if you have strong evidence, I think it is worth getting an evaluation moving forward. There's no reason not to get a specialty occupation evaluation going forward. Here's why. Specialty occupation, there's 4 different categories that you can qualify. In each category, you're going to provide evidence. USCIS may or may not push back to an extent on each level of evidence, but it's the preponderance of the evidence standard. And the more strong evidence you have, the closer you push over that more likely than not threshold. A really strong tool in that regard is an evaluation. An evaluation from a professor at a university who teaches in a field that is logically related to the type of work being done. I would recommend getting those, especially for people that are in quota this year. I cannot begin to explain how heartbreaking a situation it is when you are picked, you get an RFE, and you get a denial, because it is just so finite, that opportunity to be chosen in the lottery, that there is no reason to hold back if you have the opportunity to strengthen an argument. So what we do, I'm not going to hand you guys my whole legal playbook. If you want to come have us do an RFE response, you call us or send us an email. But what we do is we trim the situation. We do certain things so that the evaluator has as strong amount of information to draw upon when putting the eval together as possible. We have that eval, we have it packed into the response, we sprinkle it throughout, and then we also hit these points like for an operational research analyst, the high level degree requirement, the job zone level 5, all of that. So yeah, that all is to say, to put a button on this. I think you're fine. I would still get an evaluation or an RFE response though, just to be on the safe side. But yeah, I try to be a straight shooter on it. If I don't like an SOC code, I'll tell you, this one seems fine. The problem is, kind of going back to what we were talking about previously, this is a good SOC code, but you're going to see people try to put around square peg in a round hole, or however the saying is. You're going to try to have people fit positions into this that don't fit. So you might have somebody who says, well, I got a computer systems analyst, but I don't like that SOC code, so I'm going to claim they're an operations research analyst. And then if the job duties don't match up, it goes back to what we talked about at the beginning, the issue of an SOC code mismatch. So it's all part of the game and the calculus there. But yeah, you're fine as an operations research analyst. I think as long as your job duties make sense to the SOC code, I wouldn't worry too much, even if you did get an RFE.
There you go. Thank you so much, Justin, for taking this up for Lokesh. And my next question to you, Justin, is about compliance obligations. What key compliance obligations should H1B employers be aware of? Particularly regarding wages and also work location changes.
That is a great question, and it actually gives me an opportunity to spend a quick moment on something that we were actually notified of by a client the other day. So one of our clients actually called us up last week and said, we've seen an increase in site visits, but what's weird about this increase in site visits is they're almost all going to people's homes if they have their home address on the LCA. And it's not just an FD&S officer, it's also a DOL officer. So what they're doing is basically FD&S, if you know how to work the system, you can rationally push back against certain pieces of evidence that FD&S requests that are pay related because that's within the purview of DOL. But now what they're doing is basically bringing both agencies together during site visits or investigations to say, oh, well, you think you can't hand over, you're not going to hand over your pay records to us because we're FD&S. Well, here's someone from DOL, and you have to hand over your pay records to him. So anything that you think you can hold back, you can't. The point of that is to say this: compliance it's key. It is key. The Trump administration has laid down the gauntlet that their favorite word over these past 3 months, whether it's Doge getting rid of wasted spending, or the H1B program, or whatever it is, fraud. Fraud. They want to find fraud because it justifies what they're doing. It justifies the increased FD&S site visits. It justifies the increased visa revocations, RFEs, all of that. It's necessary for them to prove their work, and they're going to do that through the consulates and here in the States through FD&S. So when it comes to compliance, I mean, you're going to have to be complete. It's paramount. It's absolutely paramount. I wouldn't be shocked if, amendments filed 3 days late end up getting site visits. And if they're able to connect the dots that a person started a project early, turn around and revoke, that wouldn't surprise me. People need to be working where they're supposed to be working and being paid the wage that they're supposed to be paid. And if either of those things are incorrect, if the wages are wrong, DOL is going to be coming in some capacity, or should be. And then if the person's in the wrong work location, then you're dealing with a potential visa revocation. And as I say every time I'm on here, they really are trying to push the fact that deficiencies in the LCA constitute a material misrepresentation, which means a finding of fraud or misrepresentation. Now, that's not even necessarily true, because fraud requires someone to make a statement to an immigration officer that is, untrue or willful misrepresentation at the time they procure the immigration benefit. So if somebody actually does work in location A and then they move to location B and the employer doesn't file an amendment, it's technically not supposed to be fraud or misrepresentation because the original petition was true. All that is to say, USCIS doesn't care. USCIS is willing to say, no, we think that's fraud or misrepresentation. And remember, fraud or misrepresentation carries with it a permanent bar from the United States. And the only way that can be overcome is through a waiver acquired at the consulate or through litigation, in which you sue the federal government to have the fraud finding removed from your record. Both options take time and are difficult. So if there's any way to avoid them, it's compliance. It's ensuring that everyone's working where they're supposed to be working, getting paid what they're supposed to be getting paid, and working on the right project that they're supposed to be getting assigned to. So yeah, I think that was a fantastic question. I think compliance is going to be huge. It would not shock me at all if we saw, here's a tidbit to you that I'll give you. Something I think that USCIS is going to do. I think USCIS is going to approve a bunch of H1Bs for consulting companies for quota.
Mhm.
I think they're gonna do it. I think it's gonna be a lot of cases that they're gonna put through and say approve them, approve them, approve them. Those cases are going to get site visited the first week of October. I think the very first week of October, they are going to site visit consulting companies at a high level because they're going to look for the consulting companies that filed generic petitions that did not assign individuals to a specific project and then go after them to say, you didn't have actual work available on day one. Like you said, this is a deficient petition revoked with a finding of fraud or misrepresentation.
Well, thank you so much, Justin, for taking that up. And I'm going to quickly rush to another question because we just have 5 more minutes. So,
I know.
fairly,
I'm so sorry. I'll try to get back on soon.
yes, I hope so also. So let's quickly take our case question. Do you think when USCIS announces the total H1B registration for this year, it could be 250K to 300K, which would mean a higher selection rate compared to previous years?
Yeah, I look. I don't know the exact numbers. Like if I had this level of clairvoyance, I wouldn't be here. I'd be in Vegas getting rich. But I definitely think that based on trends that I've seen from myself and some of my associates that I speak to at other firms, the amount of registrations has gotten lower. It looks like it's gotten lower. So it would not surprise me if we see a higher selection rate because there's just a smaller pool this year. And then with that smaller selection rate, if you couple it with the probability of less filings and an uptick in denials, my personal holding is that we're probably going to see a denial rate like the last Trump administration first year that hovered close to 20%. I hope I'm wrong. I would really like to be wrong, but I think that 20% is realistic. But we'll have to see. But yeah, I definitely think there'll be more selections this year. I can't remember the exact selection rate. I think it's like somewhere between 13 and 18% or something like that, like close to 20 if I remember right. If I'm wrong, shoot me. But I think we'll see an uptick to that. Hopefully 25 to 27 or 27.5 or something like that. But yeah, I think it's a good year to be registered. Whether or not it's a good year to get the H, I don't know, but I think it's a good year to be registered.
Okay. Thank you so much, Justin, for taking that up for RK. And we'll quickly address a couple of Facebook questions from our Facebook groups. So, Control, this is the first one from an anonymous member. I'm currently working on an H1B visa through a C2C arrangement. My client manager has informed me that they're laying off contractors and asked if I would be interested in converting to a full time position. I am interested in converting. My I-140 was approved 4 months ago, meaning I need to wait the mandatory 6 month period with my current employer. My question is when I transfer my H1B after the 6th month period, do I need to provide my new employer with the I-140 approval notice for the visa interview or visa transfer, or just is it the H1B approval notice sufficient?
So when you're going over 6 years, you got to show eligibility, right? And one of those ways to show eligibility is you got that approved I-140. So it's always best to have that. If you don't have the approved I-140, what you got to do is, like you said, you got to FOIA. And when you FOIA, they're not going to give you the I-140 approval. They're actually going to give you the I-140 petition with the stamp from USCIS affirming the case is approved. It's either going to be a stamp or there's going to be handwritten information in there. So what you do is you use that FOIA'd I-140, that plus the USCIS case status page, which is available online to show that the I-140 is approved. So you put both those documents there and a copy of the most recent visa bulletin showing that you're not eligible to adjust status, and you're good to you're good. I've had to do that with several clients where they have asshole employers that won't give them a copy of the I-140. That's the workaround for it. So as long as you do that, you should be fine. Even if you don't have the I-140, the FOIA I-140, when you file, just provide the case status page showing the case is approved and a copy of the FOIA request. You might get an RFE, you might not, but even if you do get an RFE, you're going to have 3 months to respond. It's going to give you plenty of time to get the FOIA information, and you can just put it in the response. You should be able to get an approval.
Okay. Thank you so much, Justin. And I think one last question, if time permits.
Yeah, I can do one more real quick.
Okay, question on re-entering the USA with less than 60 days validity of H1B stamp. I'm planning to return to USA mid-April, while my H1B stamp on passport expires first week of June. I have I-797, a valid one until 2027, and
Yeah.
I-194. Yeah, I know.
Sorry, I just because since I know
Sure.
we're low on time. So no, it shouldn't matter as long as you have 1 day of availability. The stamp permits you entry. I will give you a caveat to that. I did have one person who got put in secondary inspection because their visa was only good for a month.
Mhm.
And that was weird because their H1B approval was good for, I think, 2 years, something like that. But they got put in secondary. It's a bogus reason to put someone in secondary, though. The fact of the matter is, the visa, the visa is what gives you entry into the country, basically. And as long as it has validity, you can enter. So 60 days, 30 days, 3 days, it shouldn't matter. What matters is that you have a valid H1B, you have a visa to come in, and you have work to be done. Now, just to be on the safe side in the present climate in which we exist, because traveling right now is not cool. Going through CBP, not a good time. They are looking for pretenses and justifications to put people in secondary. If you have this type of situation, 60 days before expiration, should it matter? No. Will an officer say it matters? Possibly. So just prepare as if you're going to secondary. When you come in, be ready to turn over the phone number of your employer. If you work for a client, the phone number of the client, your manager's name and information. Be prepared to have them look through your cell phone or laptop to show that you have proof of an active, ongoing work assignment or project. As long as you have those things, they can pull you into secondary. They can't do anything to you. So, to conclude your question, no, it should not matter. I have heard of one instance in where it was used as a pretense, and that was where it was less than 30 days. That being said, 9 times out of 10, you should be fine. But everyone nowadays, everyone should prepare to enter the US as if you are going through secondary inspection. Just make that assumption and you'll always be prepared. And if you're saying, "Wow, Justin, you're over, you're freaking out," okay, go look online and start looking up stories of expedited removals since January 20th. Go look. They're there. The information's there. There are plenty of stories of people since January 20th who had no idea there was something wrong with their
Yep.
visa, or there was no problem with them entering at any time before, that have undergone expedited removal since that time. So it's happening, and I think that it's something that's going to continue to happen throughout the pendency of this administration. So just to put a button, you should be fine, but just assume that you're going to have to answer questions in secondary. If someone asks you why is your visa expiring in 60 days and you're entering the U.S., that's a stupid question. An answer can be, my understanding is my visa is valid at the time of entry, therefore I'm permitted entry into the United States. That's it. That's all you have to tell them, and you should be fine.
Thank you so much, Justin. And I think with that, we will have to wrap up our session for today. Thank you so much for your time and for joining us. And it's a wrap. But before we go, if you still have anything more to add, Justin, please, yes, any last message maybe to everyone watching us right now?
Just good luck with everyone in the lottery. Wish I could stay on longer, but I got to go. I'll be back on as soon as I can. Pleasure speaking with you as always. You guys have a great day, okay?
Thank you so much, Justin. You too. And we'll
Bye.
see you soon. Bye bye. Folks out there, you can contact attorney Justin Rivera, and that you can do by going and emailing him, but also you can call him on his number 844-592-7336, and his email address is support@wasden.law, and go visit www.wasden.law to get to know more about attorney Justin Rivera and Wasden Immigration Litigation. Also check them out on LinkedIn, Wasden Immigration Litigation. And thank you, each one of you, for joining us today, for your time. And RK, Rick, I'm so sorry we couldn't take up your question, but I'll save up for the next time Justin joins us, maybe. And Lokesh, Ananya, thank you so much for joining us. Also, Komal, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And you can also check us out on LinkedIn, Facebook, X, and also on Instagram. We are Immigration Talk Show. So you can also email me or WhatsApp me, whatever questions you have, and that way maybe I can direct them to the attorneys when they join us on shows. So my phone number, where you can also WhatsApp me, is 408-335-6444, and my email address is nipa@staffingly.com. And don't go anywhere, because there's more coming up on Immigration Talk Show, and it's just Nipasa saying bye for now.